voluntary intoxication, drinking and assaults, or drugs and assaults. When as criminal defense lawyers, we're going to try to give our perspective on when can you claim that you were too wasted, basically, to form the intent to commit an assault or the intent to commit a crime.
Okay, now in this type of a situation, what you have to look at is this isn't going to help you out in a DUI. Just no way at all is this going to help you out, because the element of the offense there is you were drunk and you're driving. They don't care how wasted you were.
They don't care what your intent was.
No, you don't have an intent. The element of that crime is you're driving while you're hammered, and that's it.
Or you're over a .08.
.08, and even then, you don't have to be a .08. .08 is the legal presumption that you're drunk. I've had clients that have gone down on a DUI on a .02 because they can't handle their liquor.
Or a negligent negligent driving. But anyway.
Any rate, what you want to look at here is these are cases where somebody is so hammered that they black out. Yeah. And what you need to look at is, first off, does the crime have a particular mental state? Assaults do. Any assault charge in Washington requires an intent. You have to intend to do it. 2, is there substantial evidence of drinking? And this can be established with bar bills and people you were with, witnesses, that sort of thing. If you've been drinking alone, sorry dude, but you're not going to be able to get a hold of this defense because nobody's going to believe you. The third element is that you've got to present, they're not going to believe you.
Well, you could come in with bar bills. It's an uphill battle.
It's a huge uphill battle.
Right.
And the third element is that you've got to present evidence that the drinking affected his or her ability to acquire the required mental state. Mm-hmm. And the issue here is the evidence must be reasonably and logically connected to the defendant's voluntary intoxication with the asserted inability to form the required level of culpability to commit the crime charged. Mm-hmm. Evidence of drinking alone is insufficient to warrant the instruction. Instead, there must be substantial evidence of the effects of the alcohol on the defendant's mind or body. So, go ahead.
Oh, well, I mean, first and foremost, it's crucial. It's not just drinking. Yeah. It's substantial drinking. Right. You have to be drinking to arguably either black out, brown out, something where you really don't know what's going on. And then you have to be in a unique set of circumstances, because remember, this is all jury. At the end of the day, the best right we got in the United States is at least you can go argue it in front of a jury.
Right.
So you're going to ask a jury to excuse your behavior because you're too wasted. So it also becomes kind of a fact-specific game, right?
Right, but once again, this is not a true affirmative defense. All you're saying is, hey, convict me of the lesser included, don't give me the main charge because I was too hammered to be able to form the intent necessary for the first or second degree. Give me third degree, give me fourth degree, but don't give me 1 or 2.
Yeah, I mean, you're not saying that's right, it's justified or excused. You're saying I just didn't have the intent to do it.
Right.
It's kind of a mea culpa. Exactly. My fault. I'm so sorry. You have to be very regretful and sorry for that event. Certainly, I would hope my client is in front of a jury. It's a legitimate argument it's a legitimate argument with prosecutors. They don't like it, but they know we'll argue it.
Right. And why take the court's time and the prosecutor's time to go into court and say, look, I was hammered. I agree I was hammered, but I didn't do that. Yes, was that the end result of what happened? It certainly was, but I didn't intend that. What I intended to do was try and get out of there, and instead I headbutted somebody or I punched somebody, shattered their nose. I thought I was just pushing them in the stomach to get out.
Yeah.
So intoxication may raise a reasonable doubt as to the mental state required for a conviction of a certain degree of crime, but it's not going to excuse it.
Yeah, and voluntary intoxication, in my experience, it has a lot to do with, that's what you're putting on the table as part of your negotiation to get a lesser crime or to plead to something lower.
Right.
It's really not the strongest kind of case you want to run in front of a jury.
No, if you've got a voluntary intoxication defense and that's all you've got, we can probably help you get a lower degree of crime, but I don't believe it's going to be enough to get it dismissed.
Well, depends on the set of facts.
That's true, but typically not.
Yeah, typically. Anyway, if you have this problem, contact a lawyer that knows what's going on, tried these kinds of cases, talks about these kinds of cases, is interested in these kinds of cases. Call us.
Just call us.
Sit down and we'll talk to you about what's going on.
Call us.
Thank you.